Well, welcome again. After this historical background, we are not going to concentrate on the political termination of war, on the scope and limits of the political termination of war. We have two distinguished speakers with us. Professor Mamadou Hébié, bienvenue. You are Assistant Professor of International Law at the Rosoux Center for International Legal Studies in Leiden University. And like Thomas Grant before, you graduated from Harvard Law School and you already received several prestigious prizes. Welcome. Dr. Ralph Wilde, you are a member of the Faculty of Laws at University College London. You currently focus on an interdisciplinary research project called Human Rights Beyond Borders. I'm so pleased to hear that there are people interested in interdisciplinary research. And your book on international territorial administration was awarded as well, the Certificate of Merit. So we are in extremely good company to learn what is at stake in terms of termination of war, politically speaking. You will take the floor. Thank you very much.
Okay, good morning, everyone. Thank you very much again for having me. The organizers of the conference have assigned to me the task of speaking about the mandate system of the League of the Nations. And when I received the topic, I thought about addressing it from the perspective of the general idea of the conference, peace through law. But then I realized that this leading idea of peace through law did not impact so much the creation of the mandate system. Rather, the actors at that time saw the mandate system as a new era, a new form of terminating politically war. And because they conceived it as a new project, I thought that what could be very interesting to do was to consider whether the new project was as such completely new. What was new in the project? What could be considered as a remnant from the past, and what we can learn from it when we look at the developments that occurred later. So the first element of the presentation, therefore, focuses on this idea that the mandate system was completely a new project. And the idea that the mandate system was a new project, I think someone has to show. No, this, no. Excellent. The idea that the mandate system was a new project was reflected by Wilson. Wilson's idea was that the political termination of the war should not follow the traditional manner in which European powers have terminated their conflict. Rather, in 1919, there should be a new ideology. What were the components of this ideology in Wilson's mind? When you read the preamble of the 14 points, one of the first things that you see is that it says, the day of conquest and aggrandizement of territory are gone. The idea that you could use war in order to conquer territory is considered to belong to the past. We are now in the beginning of a new era. The second element that you find in Wilson's 14 points in the preamble is that as the United States, as at least is concerned, they are not requesting anything from the war. They are almost benevolent. They are almost participating in creating a new system where their main goal will be the interest of the system, but not as such American interest. When you compare this to what is happening today, you can see some differences. And then the third element that you can see also from the preamble is that they are considered that justice and fair dealing with other people against force and aggression is a cornerstone for establishing the new system, and the new system has as one of its elements the mandate. Point 5, so this was just the preamble. It gives you a sense of what Wilson was thinking about when he was considering the political termination of war. And then point 5 of the 14 points says that it is a free, open-minded, and absolutely impartial adjustment of colonial claims that will become a cornerstone of the system. We will try to think about the new system in an impartial way. We will try to consider it, to consider both the interests of the populations that are concerned and the equitable claims of the government. Not all type of claims, the equitable claims of the government. So what is there is already this idea that the system will be aiming for justice, for fairness, and in a certain sense for equity. In February, this was in January, in February, Wilson had to make also a speech before the Congress in order to tell the American people what the US will be seeking in the peace negotiation. There you have 4 points. I think that the second, from the second point, it becomes very relevant for our purpose. It says that peoples and provinces are not to be bartered about from sovereignty to sovereignty as if they were mere cattle and pawns in a game, even the great game now forever discredited of the balance of power. Here is again this idea of departure. The past was governed by the principle of equilibrium. The new legal order that is being established will be governed by other principles. The interest and the system will be established in the interest and for the benefit of the population concerned. The 4th point deals with the principle of nationality, which is not exactly what I will be focusing on. So what were the idealistic elements in the mandate system that was established under the League of Nations? The first one is to consider that there is no right to annex territories that were conquered during the war. If you compare it to the international law system existing at that time, conquest was considered to be a lawful title of territorial sovereignty. Actually, during the war, Great Britain and France were occupying German territories in order to annex them. So the idea, the first element that the mandate system introduces is this idea that conquest is no longer a title, will not be a title for territorial sovereignty when dealing with the political termination of the war. I don't believe in the general idea that there was no prohibition on the use of force during the 19th century. It's quite common for international lawyers to say so, but whether there was a prohibition of use of force in the 19th century or not, one thing was certain, that after the war, the victorious power could extract from the defeated powers the right to their territory, especially through a peace treaty. A peace treaty could be used irrespective of the legality of the war in order to establish territorial sovereignty. The only exception that we have in this regard is in the Latin American context. When the Pan American Conference, the first Pan American Conference, says that as long as the arbitration treaty is in force, no Latin American country will recognize acquisition of territorial sovereignty through conquest. But this was a regional legal order. It was not yet at the international level. This idea that conquest cannot acquire territory became one of the first elements of the mandate system, and it proves in some way that the general philosophy of departing from the old system was somehow present in the mandate system. Now, I'm moving to the second point, the second element of idealism, the second point of departure from the old system. This second point relates even to the idea of a mandate. The right of civilization existed. You read Victoria, you see Victoria believing that there are certain Indians that might be that are not capable of governing themselves, and it would be better to place them under the sovereignty of the Spanish crown. This is already in the 17th century. The idea that Europeans had the right to establish sovereignty over a certain population because of characteristics relating to their culture, their level of socio-political organization, has always existed. It did not apply to all political entities. It applied essentially, at least from my point of view, to the entities that were known as slave by nature. So no one tried to consider that the Great Khan would be subject to the sovereignty of Spain and others. In the 19th century, the idea of civilization is still there. You have the Berlin Conference. The parties disagree about several things, but they don't disagree about the idea that it is right to divide spheres of interest and among each other, or even to establish rules governing the opposability of titles that will be acquired in the African continent to each other, West Africa to be specific. But in 1919, the logic is slightly different. It's not merely this idea of civilization, it is rather a logic of institutionalization of the burden of civilization. In the beginning, there were rather individual attempts by states, both converging with the idea of civilizing non-European countries, but in 1919, the idea is rather to institutionalize it. We will have, within the framework of a league, a general mission of civilization known as the white man burden, the sacred trust of civilization, etc., in an institutional context. And how would it operate? It operates in two ways, which are very, very interesting. The first one is that the defeated power have to renounce to the sovereignty over their territories. Before establishing the international regime, you have the defeated powers have to renounce to their title to sovereignty over the territory. This is very, very important. When you think about secession, one of the real reasons why secession is so contentious is the fact that the mother state has not relinquished the sovereignty over its territory. And this is where the conflict of claims start. Germany abandons the sovereignty over its colonies, Article 119 of the Versailles Treaty. Turkey, it's a little bit more difficult. They try to force it to abandon its sovereignty over its territories in the Sèvres Treaty, but then they succeeded in Lausanne to get and it creates, again, an interesting problem. If the defeated powers are not sovereign over the territory, then who is the sovereign? Who is the sovereign? Is it the League? Possible but not certain. Is it the population of the colonial territories? You could say that with respect, for instance, to a mandate, for instance, Iraq, but it is very less likely that those population inhabiting the Pacific Island were considered to be the sovereign over their own territories. Doctrine has tried and has gone different ways. I think that when you read literature and you realize that they try to find a locus to sovereignty during that period, is also because the mandate system was something so new, no one could think about just an internationalized territory. Sovereignty doesn't belong to anyone in this territory. The territory is subject to an international regime. Perhaps sovereignty will be determined later, but at the moment, does not belong to anyone. It belongs, the territory at stake is subject to an international regime. Now, what were then the populations that were considered in the mandate? There you have three categories, A, B, and C. Simple letters, easy to follow. They were you have the first colonies, which were considered, now here you have the general philosophy of the mandate, which is based on the sacred trust of civilization. I already discussed that. But then you have certain communities belonging to the Turkish Empire, which were considered to have reached a certain level of development, good enough to foresee their independence in a near future, but not sufficient enough for independence to be immediate. And as part of the burden of civilization, it was normal that the colonial powers and the mandatory power in this context will be helping them in the process of being fully fledged independent state. They were thinking about Iraq, they were thinking about Lebanon, they were thinking about Syria, and they were also thinking about Palestine, of course, very topical today. The B mandate are not clearly defined, by the way. They say that the level of development is at such a stage, so you put there what you really want to put. The level of development is at such a stage that the mandatory power must be held responsible for the administration of the territory under certain conditions. The conditions are interesting, but some of them, the majority of them, existed already in the Berlin Conference Treaty of 1885, in the Brussels Treaty of 1890, so I don't focus on them, perhaps only to say that the prohibition of slavery has been extended to the prohibition of forced labor, and that was quite relevant in the context of the league. And then finally, there are other territories, such as Southwest Africa, and certain islands in the South Pacific, in the Pacific Ocean, which, owing to the sparseness of their population, their small size, the remoteness from center of civilization, or the geographical contiguity, can be best administered under the laws of the mandatory as integral portion of its territory. Here you see that the system is getting close to annexation, because they are suggesting that these territories will be administered almost as integral parts of the territory of the mandatory power. But then it's still subject to the safeguard mentioned above for B mandate, so prohibition of slavery, trafficking of arms, etc., etc. These were new in the system, but a final element of novelty in the mandate system relates to the fact that it tries to institutionalize what I call in French le droit de regard, meaning the right to scrutinize how the mandatory power is complying with its obligation under the mandate. 5 minutes left? Left? Really? Okay. I thought I was 25. Okay. No? Okay. So that was the other element that I will talk about, but I think we will get a chance to go in depth on it when we speak about the judicial clauses that existed in all mandates authorizing referral to the PCIJ for this case. The fact that the League established the Permanent Mandate Commission, which was entitled to review annual reports from the mandatory powers. Now, why do I believe that the mandate system was still not as idealistic as I thought. The mandate system was also part of a big real political bargain. And this is not something that should be occulted. The first element of the real politic in the mandate system is even the manner in which it is established. Germany relinquished its title of territorial sovereignty to whom? To the Allied powers. These Allied powers will have to decide what will be done about the mandates. And it is the Allied power who negotiate the terms of the mandate. It is not with the League that the terms of the mandates are negotiated. They are negotiated with the mandate, with the Allied power, and endorsed by the Council of the League. Germany contested that it is not exactly in line with Article 22, but to no avail. Another element then that I need to mention is that even the mandate system tried to guarantee the old political interest that the victorious power had acquired through the war or during the war. You remember the Sykes-Picot Agreement, where Russia, France, and Great Britain started to share the spoil of the Ottoman Empire. The Balfour Declaration, where Great Britain takes commitment for a homeland for the Jews. If you look at the allocation of the mandates, basically it reflects the allocation of territories under the Sykes-Picot Agreement, except Russia, which due to communism did not want to be part of this, let's say, of this bargain any longer. And then, what about the other powers which were in the League? The US said that it was a benevolent broker in the mandate system, but that was not true. Actually, the idea of internationalization of the mandate system, of the territories under mandate, aimed at avoiding them falling under the sovereignty of one of those powers which had already conquered them or which already possessed them at the end of the war. Under their sovereignty, these territories will not be open to trade. They will not provide necessarily national treatment to American nationals. They will not be automatically extending the most favored nation treatment clause within these territories. So the American, although they did not have territorial gains in mind, they had economic gains, especially with respect to Iraqi oil. So Iraqi oil is not something that started in 2000. It existed already in the mandate area. I know that I don't have enough time. What can we keep? What do we gain when we look at the mandate agreement from this perspective? We saw that it was a new bottle, something completely new, because it had it reflected ideas that did not exist, at least under international law when it was adopted. But the content reflected good old diplomacy of realpolitik. So you have a new bottle where you do put your old wine. The legacy of the mandate system is that, first, this idea that war does not give a title. I think that it is a major contribution of the mandate system, and it's not surprising that the US, who champion it, are the one who also made the Simpson Declaration. We will not recognize title of territorial sovereignty acquired through an unlawful war. The second element is the bottle. In certain wine, the bottle is even priceless, more precious than the wine that is in the bottle. And the fact of institutionalizing this, that I prefer the French term droit de regard, because it does come with a lot of implication. The fact of institutionalizing the droit de regard, the fact of initiating the control through reports of the management of the mandate of the mandates, triggered what we know somehow to be the human rights system. And I will be able to talk more about it in the discussion. But one element that the mandate system did not do, the mandate system was not anti-colonialist. It was an attempt to regulate colonialism. It was an attempt to make it softer, nicer, better. But whatever adjective you might want to put it, it was not against colonialism. Only one state became independent through the mandate system, and it is Iraq. It is Iraq, but not because of the mandate system, but because of the fact that they resisted UK's mandate over the territory. So the mandate system was not aimed at that. But even in 1945, the idea, so just 2 minutes and I'm gone, and I'm done. Yeah. Even in 1945, the mandate system still proved popular. Instead of Article 22, the drafters of the charter added 2 chapters to govern the mandates. And the element then which the mandate system did not have come only in 1960 when they adopted the Declaration for the Decolonization of non-self-governing territories, including also mandatory. What you can see there is point 1 of Resolution 1514 says, inadequacy of political, economic, social, or educational preparedness should never serve as a pretext for delaying independence. This throws away completely the entire philosophy of the mandate, because the mandate system thought that under these conditions you will try to educate or help this population to reach a level where they can govern themselves. No, we're going too fast.
No, I think it was not too fast.
It was great. Do you really think so? No. And then point 1 says that the subjection of people to alien subjugation, domination, and exploitation constitute a denial of fundamental human rights, the UN Charter, but is also an impediment of to the promotion of world peace and cooperation. So then the new system ties up with the idea of peace through law by considering that certain situations that can be peaceful in the sense of no war can still be considered as not just peace through which we can, it can be considered as not condition through which we can establish lasting peace. So thank you very much for your attention and for your kindness for the extra minutes.
Thank you so much, and sorry for being so frustrating.
Great, thank you. Well, it's a great pleasure to be here. Thank you so much to the organisers for including me in the programme, and more generally to your wonderful team and all their great practical assistance, which has been outstanding. So thank you. Now, when states administer territory that's not their own sovereign territory, and international organizations administer territory, collectively what I term foreign territorial administration, the focus in expert commentary tends, and broader discussion, tends to be on particular instances or clusters. So the Palestine Mandate, the occupation of Iraq, the UN administration of Kosovo and East Timor. Even when broader frames of reference are followed, it's common to cluster according to and analyze exclusively within four particular categories. First, belligerent occupation by states. Second, colonialism. Third, state administration under the mandates and trusteeship systems. And fourth, international territorial administration. And also a tendency to essentialize on a policy level these activities via an exclusive association with particular policy objectives. So state building, self-defense, abuse and exploitation, addressing territorial disputes, enabling or preventing self-determination, etc. Now, these approaches are, of course, helpful for some purposes, but then in other respects, a central commonality is ignored, which, when appreciated, casts each individual activity in a different light and ignores a central institution in international public policy over the past 2 centuries, and also how the radical change in the fortunes of this policy institution, taking place roughly halfway through what we might call the Versailles centennium, how this change had a profound transformatory implication for all of the activities. And a clue as to the nature of that change is indeed in that quote. Now, what I want to do is explain this commonality. My reasons for doing so at this conference about Versailles is that arguably the single and most important moment in both its development and the beginnings of a countervailing principle that would be its undoing are both found within the Versailles Treaty. Now, all the general types of foreign territorial administration were addressed in Versailles, with belligerent occupation in, for example, the stipulations concerning the occupation of the Rhineland. With colonialism, as we've heard, of course, Versailles affected the removal of the colonies of the defeated powers, transferring them to the victorious powers to be administered as a new form of colonial arrangement under the auspices of the League, the mandate system. With international territorial administration mentioned yesterday by Nathaniel, Versailles provided for a 15-year League administration of the Saar, not far from here, of course, to enable the reparations-based resource extraction there by the Allies, and in creating the League of Nations, more generally, established the body that would then be available to be used in subsequently created international territorial administration arrangements, the League Commissioner in the Free City of Danzig, and the League administration of the town of Letitia on the border between Colombia and Peru, often overlooked, and also often overlooked the League member on the harbour board in Memel, now Klaipėda in Lithuania. But as well as implicating all forms of foreign territorial administration, Versailles also articulated 2 normative principles that are of essential significance to this activity, in that they speak to its legitimacy. First, what I'll term trusteeship over people on the one hand, and self-determination on the other. So beginning then with trusteeship over people, in the book that was kindly referenced by our chair that I published in 2008 with OUP, I argued that this is a concept in international law and public policy which can be identified across all the 4 manifestations of foreign territorial administration I set out a moment ago. As far as legal articulations of this policy are concerned, this is the link between, for example, Berlin, so the already mentioned General Act of 1885 in relation to colonialism, The Hague, the regulations of 1899 and 1907, grafting on trusteeship ideas to occupation law, Versailles, the covenant in relation to the mandates, and then, of course, San Francisco with the charter in relation to both trust territories, which were the UN equivalent to the mandates, and other colonies referred to in the nomenclature of the charter, of course, as non-self-governing territories. This concept of trusteeship over people is deployed to explain the basis on which foreign rule should operate and potentially the basis on which it might be brought to an end. The introduction of trusteeship was understood as a response to two distinct conceptions of the pre-existing governance structure in the territory. In the first place, covering colonial trusteeship as well as state-conducted foreign territorial administration under the mandate and trusteeship systems, we have, of course, the racialized concept of a standard of civilization deployed to determine that certain people in the world were uncivilized, lacking organized societies. Arguably, the most symbolic articulation of this is indeed in Versailles, in Article 22 of the Covenant, with its reference mentioned yesterday by Nathaniel to people in mandated territories as being, and I quote, not yet able to stand by themselves under the strenuous conditions of the modern world, end of quote. In the second place, also covering certain forms of colonial trusteeship, foreign state-conducted territorial administration under the mandate and trusteeship systems, occupation, and international territorial administration, foreign rule was introduced after conflict, sometimes allied to particular related objectives, such as punishment for defeat, as in the transfer of authority effected through the mandate and trusteeship arrangements, or to enable reparations, as in the Versailles-created League administration in the Saarland. Understanding the exercise of administrative prerogatives over territory in these two circumstances as trusteeship conceptualizes the relationship between the foreign actor and the territory and its people in a particular manner. The trustee-guardian entity controls the beneficiary ward territory and its population, acting on their behalf. And again, Versailles contains the most prominent articulation of this, the, and I quote, sacred trust of civilization, relating to the mandate territories. Now, in many, although not all instances of trusteeship over people, the role of the trustee state or international organization is understood to have a two-part character. First, to care for the ward, and second, to exercise tutelage of the ward to ensure that it can mature and eventually care for itself. Thus, again, Versailles articulates the objective of the, and I quote, well-being and development, end of quote, of the people in mandated territories as the objective for trustee administration. So in these articulations, Versailles consolidated a development that had been in train through association with certain instances of colonial rule and the more generalized articulation in the African context with the Berlin General Act, and of course in the occupation context with the Hague Regulations, expanding things to cover an entire broad class of territories and, for the first time, as has been mentioned, supervised by the new plenary international organization. Thus, Versailles involves fully internationalizing the concept of trusteeship over people conducted by states as both a legal obligation and subject to an international supervisory mechanism. Moreover, in establishing the League, it created the potential, realized in Danzig, the Saar, and Lutetia, of trusteeship over people in a further internationalized form, not supervised by a plenary international organization, but carried out by it. The commonality between the different forms of foreign territorial administration has been perhaps more apparent to expert commentators in the past, as it seems to be to most observers and practitioners of the recent international territorial administration missions, as in Kosovo and East Timor. So writing in 1939, for example, Quincy Wright stated that the League's administrative activities in Danzig and the Saar were analogous to the mandate system. Similarly, discussing the League administration in the Saar and the mandate arrangements, Duncan Hall asserted in 1948, and I quote, "What matters is the substance and not the form. The Saar territory was under the Saar Governing Commission and not the Permanent Mandates Commission. Such differences are largely a matter of the internal economy of the League, end of quote. So Versailles is a landmark not only in the internationalization of the trusteeship obligation and the introduction of trusteeship over people carried out by states and international organizations, also, as I mentioned, in its creation for the first time of an international supervisory mechanism for trusteeship, the Mandates Commission. How did this happen, and how does it relate to colonial ideas of colonial trusteeship? Well, of course, colonial trusteeship itself, for its proponents, was a means of reconceiving colonial rule as humanitarian, in some cases to replace earlier forms of such rule understood as having been exploitative. In the context of the belligerent occupations to which the Hague Regulations apply, the desire was similarly to prevent abuses and exploitation commonly associated with such occupations in the past. Indeed, trusteeship requires accountability because of the imbalance in the power relationship between the trustee and the ward, and the resulting possibilities for abuse. As Michael Riesman observes, the requirement of accountability is rooted in the fact that, and I quote, the power relationship between the parties concerned is manifestly asymmetrical, end of quote. In other words, it's not enough to humanize, supposedly, forms of foreign domination to ensure that they operate for the benefit of the local population. There must also be mechanisms to ensure that these humanitarian standards are adhered to. So those who advocated reconceiving colonialism to operate on the basis of trust did so in part because this would then provide a basis for subjecting colonial administration to third-party review. So Edmund Burke regarded accountability to be, and I quote, of the very essence of every trust, end of quote. The accountability arrangements for the mandate system, of course, established internationally enforced accountability for colonial trusteeship, albeit not all colonies, of course, only the mandates, for the first time. Oversight of different kinds, as was mentioned, was provided by the League Assembly, the Council, the Permanent Mandates Commission, to whom individuals could bring petitions, the mandate section of the Secretariat, other League bodies, and of course the possibility of issues going before the Permanent Court. This set the template for the somewhat equivalent arrangements operating under the Charter for both trust and non-self-governing territories. Now, as we know, the UN Trusteeship Council was mothballed with the end of the final trust arrangement in 1994. However, the trusteeship system was and still is potentially open to further territories, and as a matter of the Charter, can include arrangements where the administering authority is not an individual state or states, but the organization itself, the UN. And indeed, some commentators propose that the Trusteeship Council should have been revived to provide oversight of international territorial administration missions. East Timor, for example, the mission there, fitted somewhat loosely into the category of a trust territory when the UN mission began in 1999. It had been detached from what was, in effect, a kind of colonial power, and its people were deemed incapable of self-administration in the short term. Despite this, the Council, of course, was not revised to supervise it. And indeed, in 2005, the General Assembly resolved to abolish the trusteeship system, including the Council. Not only were the international organization conducted trusteeships, like in Kosovo, East Timor and Kosovo and Bosnia, etc., not subject to much international oversight, their practice was commonly criticized on human rights grounds. And underlying this commentary was the widely held assumption that international territorial administration should be made fully internationally accountable. If the UN is acting as a territorial government, then it should be subject to the same checks and balances as any other territorial government. And of course, in this context, it's common for observers to point out the irony of the UN seeking to promote democracy, human rights, and the rule of law, while itself operating in a manner that is undemocratic, violative of human rights, and above the law. And as far as mechanisms to remedy this at the international level go, critics then often called for the Trusteeship Council to be revived to supervise the UN administration missions. Now, what all these approaches overlook is how the accountability of international territorial administration is not, in my view, accidental, but actually structurally linked to the two sets of broader normative ideas relating first to the legitimacy of international organizations and second to the self-determination entitlement. And I think to fully appreciate this, again, it's important to return to Versailles. In the first place, trusteeship, as conceived under Versailles, also operated in the same normative climate as recent international territorial administration missions. State-conducted trusteeship under the mandates was subject to international supervision, but League-conducted territorial administration was not brought under an equivalent mechanism. This, of course, implicates the irony of Juvenal's famous question, quis custodiet ipsos custodes, who guards the guardians themselves, as it's the actor who would normally be the enabler of international accountability who is now the entity in relation to whom accountability needs to operate. But Versailles also reminds us that the role of the League as territorial administrator was seen as desirable precisely because the organization was seen normatively as qualitatively different from the states who would be the normal choice as territorial administrators. The League is the first attempt, of course, to create a plenary permanent institutional body above states acting supposedly in the interests of the international community as a whole. This has particular implications for trusteeship, enabling a sharp contrast to be made with the idea of states as always potentially imperial, self-serving, and exploitative. However simplistic and problematic this contrast is, it can certainly be seen as having been effective in practice in obviating the need for international accountability for international organization-conducted trusteeships. Now that a supposedly selfless humanitarian actor representing the common interest is directly involved in territorial administration, the concerns that led to calls for accountability in the context of state-conducted trusteeships are seen to fall away. The second lesson from Versailles speaks to a further key normative regimes in international law and public policy that is often strangely overlooked in discussions of trusteeship and yet is essential to understandings of it. Now, one of the ways, of course, in which Versailles is a landmark is in the development of the concept of self-determination in international law. And as we know, roughly halfway into the post-Versailles centennial, this concept was transformed as a matter of international law into a principle that, of course, repudiated the legitimacy of the idea of introducing and maintaining trusteeship over people, especially in the colonial context. So to modify the seminal articulation in the Covenant, there were no longer people who were not yet able to stand by themselves. Thus, the alibi for colonial rule was removed. Administration by outside actors, necessarily preventing self-administration, was considered now ipso facto objectionable. So formal freedom and independence, of course, informal lack of freedom and dependence continued, were no longer to be granted if and when the stage of development had reached a certain level, as in the past. For example, ostensibly under the A-class mandates arrangements, it was now an automatic entitlement. So under Article 3 of General Assembly Resolution 1514, of course, inadequacy of political, economic, social or educational preparedness should never serve as a pretext for delaying independence. Given this normative position, it's possible that, although in fact trusteeship continued, this was only deemed acceptable in a few places, perhaps even indeed regarded as somehow an accident. More generally, of course, there is considerable international resistance to trusteeship as a general idea, particularly, obviously, between G77 states. To revive the Trusteeship Council would be to accept that the self-determination paradigm has somehow become qualified, that trusteeship is back as a legitimate feature of international public policy. A return to the worldview of Versailles in this respect. Formalizing an accountability mechanism would inevitably represent the formalizing and legitimizing of the trusteeship paradigm itself. If there's no general acknowledgement that trusteeship is back as a legitimate feature of international public policy, then it becomes more difficult to make the case for greater accountability. The denial of accountability, then, is in one sense structurally linked to the self-determination entitlement. Versailles is at once, then, an instrument that marks the high point for international trusteeship over people, but also contains in embryonic form a concept, self-determination, which would develop into something that would place the legitimacy of all forms of foreign territorial administration into question. At the same time, in creating the first general international organization and involving this body immediately in direct territorial administration, Versailles is the forerunner of an arrangement that resurfaced in the post-colonial era to reintroduce trusteeship over people in limited places, in a normative climate that is at once ambiguous on the matter of legitimacy and lacking accountability, for reasons that can again be traced back to a concept, self-determination, that has its origins at Versailles. Thank you.
Thank you very much for your presentation, which is so inspiring in many ways. So both of you, you told us stories about the good old diplomacy of realpolitik and civilization, wonderful picture, and you gave us food for thought, so the floor is yours now.
Hi, thanks very much. My name's Aravind, and I'm a research fellow here at the Institute. I had a question relating to the notion of trusteeship and mandate. Now, as like the thing is that in there is a comparative difference in the concepts that people who grew up in different traditions will have. For an English lawyer, the idea of trusteeship almost always immediately makes you start thinking about property, about differentiated and separated titles of beneficial and legal title and property. Whereas for a civilian, trusteeship or mandate or negotiorum gestio, these have nothing to do with property at all, but they are personal obligations in contract and quasi-contract. I'm wondering, the first question is, to what extent did these sort of things that law students learn in their first year of law school, to what extent did these inform or affect the conversation between, like the different parties treating the, setting up the system of mandate, of international mandates? I can imagine that it doesn't divide neatly along, Anglo-American and civilian lines. We saw Woodrow Wilson earlier saying that sovereignty and people and provinces are not to be treated as property, to be bought and sold, right? So he's taking the classic Roman idea, whereas on the other hand, you've got Lauterpacht and Max Huber treating territory as property that can be prescripted, such as that. The second question, relatedly, is: was there a difference between how the Allied powers conceived of the metropolitan center and how they conceived of colonies? Basically, did they conceive of colonial territories as property to be bought and sold, and treat that differently from the metropolitan center? Thanks.
Yeah. So thank you very much for your question. It's true that the notion of trusteeship, when it was imported at the international level, created confusion. It created confusion, and this confusion also helped in accepting it. It helped in accepting it because certain countries, such as France, which wanted to keep full control of its colonies, said, but what is this trusteeship? We don't need to know. Let's wait 10 years later to see what will happen about the territories. So the fact that the notion was not a legal term of art created an ambivalent situation where both parties, you had the American on the one hand, the British playing the brokers, and then the France being the extreme in trying to gain sovereignty over the colonial territories, being able to agree. But it was clear from the beginning, especially from the American side, that the territories under mandate could not be acquired as as sovereign territories. So that was clear from the British, from the American mandate. The distinction. So now moving to the second point, the distinction between the metropolitan center and the colonial territory. What is very interesting is that in several respects, the question of applying the mandate system in Europe was also discussed. When the General Smoot from South Africa proposed the mandate system, he was not thinking even to German African colonies or else. He was rather thinking about applying it to Russian territories, to Central Europe in a certain respect. But it was not thought to be applied there. It's only with Wilson that it was later foreseen as applying in the colonies' perspective. But whatever we can think about the evolution of the concept of mandate, it was clear since the beginning that Christian, this is in the 15th century, European in the 19th century, territory is completely different from a legal point of view from the territory of the colonies. One simple element is the colonial clause, whereby treaties concluded by colonial powers do not extend automatically to colonial territory, except specific stipulation to the contrary. Also.
No, thank you.
I don't have anything.
You don't have anything to add. Thank you. Any other question? Yes, please.
So thank you so much for these presentations. They really raised to my mind some of the key issues, not only of Versailles, but of the whole century that that have passed since then. And I wanted to basically challenge both of you to sort of play devil's advocate in a way. And so this question is not to imply that this is your position, but to challenge you to respond to this. And it goes like this. Dr. Wilde talked about this quote from Duncan Hall, where he says that the form of foreign territorial administration might be different, mandates or the SAR, et cetera, but the substance is the same. And I wanted to put that challenge to both of you to say, what difference does law make? So that in Dr. Hébié's presentation, you concluded by saying, quite rightly, that the mandate system was not an end to colonialism. It was, in a way, well, what was it? I mean, certainly a lot of the critics of the mandate system would have said it's just colonialism under a different mask, right? In Dr. Wilde's presentation, we have this idea that the failure, if I'm understanding it correctly, the failure to revive the trusteeship council in the post-Cold War era was basically an act of bad faith. Basically, it was a way of denying. If you revived it, then you would be admitting that you were basically reviving the whole panoply of ideas that were basically colonialism with a different name. What would both of you respond to the challenge that both of your presentations are denying the effect of law, or the specific effect of law, of shaping, channeling, transforming legal form, political forms of domination? How do you see, is there a specificity to the law's effect, or do both your presentations suggest that the real thing that's going on is power exercised by foreign powers over other territories? Thank you.
Okay. I will say one thing. What is the role of law? The role of law is that whenever law is used in order to crystallize power relations, this crystallization becomes opposable to power. So somehow, power binds itself and finds itself obliged to justify any steps away from the legal situation which was accepted. One thing that is very important in the mandate system is that at the end, mandatory powers were obliged to come before the Permanent Mandate Commission and explain the measures that they were taking in their mandate. This was not for those who thought that the mandate would disappear in 10 years when the American would grow tired of the idea of internationalization. This was there. Whatever may have been the power relation, the power created a legal situation which automatically turned opposable to the entities that created it. And as far as the mandate system is concerned, one element that is very important is that it gave the opportunity to see how the individual right of petition could work at an international level. It also gave the opportunity to see how the report system could serve a cause of protecting, I won't say human dignity because these were not the concepts, but to supervise the compliance by the colonial powers of their obligation. Historians say that and I can understand it from a legal perspective, if you are the same colonial power exercising a mandate and exercising sovereignty over a territory, the simple fact of practice in complying with your mandate, the obligations under your mandate, will build in to your practice in the colonial, in the territory under your civilization. So my point was not that law is irrelevant, but I think that it is good for us, especially when we are doing the history of international law, to take a distance from the actors, their motives, and their objectives, and also what they try to achieve. Yeah.
Thanks.
Yes, so thank you very much. I'm not sure I understand. I have to think more about your question, Nathaniel. Maybe we can talk about it afterwards. If I understand what you're asking to be a distinction between law and power or politics, and that is it just power, or does the law play a role? Is that what you were asking me? Whether I?
Well, I was just sort of challenging you to state your position on that.
On the role of law as distinct from.
Yes. In other words, if I'm right in saying that you're basically
Yes.
accusing the you end up being in bad faith by not reviving the trusteeship council and thereby denying that it was exercising power, but also refusing accountability. Anyway, go ahead.
Well, because, I mean, yes. I mean, I don't see it as bad. That's very interesting. I wasn't accusing anyone of bad faith. I was interested in the problem of having this situation existing and being approved, and the contradiction between that and having not then made this revive this institution, which would foreground that. But I think it's a difference of degree, and I don't think it's the UN. I don't think anyone was actually under any illusion as to what was going on in these arrangements. So I sort of don't see it that way, and I don't see the acknowledgement. And of course, I don't adhere to a sort of distinction in that way between law and politics and law and power. I mean, there is a separate issue which maybe is not what you're asking about, which is, of course, that all of this was just rhetorical, and that, in fact, all of these arrangements were, trusteeship was merely a way of legitimizing business as usual in terms of domination and exploitation, of course, for the avoidance of any doubt, which some people do have about even my book on this topic, even though it's very clear if you read the book, I'm not endorsing this as something that was actually meaningful, adhered to in practice, followed in good faith, etc. It's nonetheless the justificatory framework which has to be reckoned with, and indeed can form a very powerful basis against which these arrangements can be assessed on their own terms. But then, of course, that isn't the end of the critical engagement with them.
Nuanced issue. Do you have any question? Yes, please.
Thank you, Laurence Boisson-Chazot. It's a question for Mamadou Hébié. You started with a presentation of the 14 points speech of Woodrow Wilson, and then you switched to the League of Nations and the mandate system. And for me, the question that I would have is that were the ideas of Woodrow Wilson really translated, integrated in the League of Nations covenant? Were there any discrepancies? And what was the idea of Wilson when he made all these speeches? Because in a way, they seem to be much more liberal than the system that you've presented in the League of Nations covenant.
Yeah, the ideas of Wilson did not fully prevail in the system. They were followed by ideas developed by the British Labour Party, by General Smuts, whom I referred to, but also the fact that the US was somehow getting away from the League did not allow it to play its role of defending fully the entirety of the system that Wilson was foreseeing. So eventually, what is left from the main ideas of Wilson that he took from the British Labour Party proposal and General Smoot is this idea of a mandate and of an international supervision. But Wilson also was not an angel. He also was foreseeing, he was also trying to protect American economic interests and their military, and also their military interests that I didn't address in the presentation. So we can say that the 14 points do not fully reflect Wilson's goals. They reflect the loftiest part of the goals, but there were other hidden agenda. But we can also say that there were resistance from France, broker role from Great Britain, sometimes supporting the French, sometimes the American, and all these contributed to dilute the ideas that we see in the 14 principles.
Any other question? Or are you going to Are we going to have the same pattern? 5 minutes. Pierre? Oh, yeah, go.
As we have time, but not to deprive you of the lunch, just a general comment. Listening to you both speeches, it reminded me of Albert Cohen, Belle du Seigneur, where we have Adrien Deum, the Belgian civil servant of the League, having to write a report about a mandate and being bored to death about it, and putting the report under a pile. And when there is law, there is bureaucracy. When there is bureaucracy, there is boredom. And and somehow those mandates and trusts issues, I mean, there is a tension there between this idea of limiting political imagination of peoples on the ground by writing history in advance, and that contrasts with so much with what is going on the ground, and how international bureaucracies function, work, imagine themselves, and are able on a daily basis to deliver on the lofty goals that are there. So this contrast is, I think, very much still with us today, but it was wonderfully explained and by personal experience by Cohen in Belle du Seigneur. But anyway, that's a general comment.
I think that it's a perfect conclusion for the morning, Pierre. Thank you very much. But thank you for this discussion that I found eye-opening, and which is to me a call for adopting a reflective posture, which is so important in life. So, bon appétit à tous.